Right? Yes. Please settle down. Yesterday I was there. The principal is telling the no class today. You are all rejoicing. Rejoicing with happiness. That means you are not ready to enter into the new life. Class is happy. All of that. So you are accustomed to old sort of thinking. Re-engineering your brain program now. There is concept is there, money, knowledge, so it's interlinkable. You understand? Time, money, knowledge, everything. Class is happy. That this is the state of affairs of your mind. Kindly analyze your what is called attitude. This is the thing where you are going to enter into new life. This is a profession which requires more strenuous mental and physical work, but you are not ready to accept this. Everybody in the afternoon sleeping. 3 years you have slept. These 15 days you wake up. Again, after completion of your class and enrollment, you can sleep permanently. Yeah, that is going to happen. You don't know the procedure before the courts. You don't know procedural law. You don't know substantive law. You know only filling system, mail application, 500 rupees. This is your life. That's it. No, you are unable to understand the technicalities of law, how it is going to be. You know who is a famous lawyer in India? That is your answer. I'm the famous lawyer. I'm applying one. Yaro, you are telling somebody's name, not your name. The name, your name is not in the list of a famous lawyer. Right. No, no, that is your name. You are telling somebody's name, but not your name. Yes, yeah. Today we are going to see award. Right? We have seen constitution of arbitral tribunal, powers of arbitral tribunal, powers of the arbitrator. Now assume that all the proceedings are in place. The arbitrator passes an award which is final, which is binding on you. Right? So arbitral award cannot be challenged except on a few legal rules. Right. Now, just we go into the meaning of this term. Arbitral award and includes interim award. That's what the definition of the Arbitration Conciliation Act states. Arbitral award includes interim award. So, again, award is a deemed decree. It is applicable in the courts of law. Now, the final step in arbitration for arbitral tribunal is making an arbitral award. Making an arbitral award. You are drawing up an arbitral award. So, last one, they are going to give you an award which is final, which is binding on you because you have consented that award is final and binding on you. So it refers to tribunal's rendering of a decision, rendering of a decision. Again, all decisions are not awards. You understand? Rendering of ஒரு decision கொடுக்கும் எல்லா decisionம் award ஆன கிடையாது. Final determination of the disputes only is a decision. Again, they will what is called give an order on preliminary issues also. They are also decision. But preliminary issues எல்லாம் கூட challenge பண்ண முடியாது. Normally procedural things cannot be challenged in the courts of law. So the tribunals rendered its decision in a manner satisfying the formal requirements of the arbitration legislation in the arbitral seat. Typically, completion of a written, it should be in writing, it should be signed, dated, and delivery of the award to the parties. Right? So, arbitral award எப்படி இருக்கணும்னா sign இருக்கணும், date is also there. Date is also there. Again, normally what happens is, you know the limitation period is there. Limitation period. For example, to enter into the contract, you enter into the contract. Now there is a breach of the contract. You know, within the particular time, you have to go to the courts. Time no in the court to go. You understand? That is one act is the Law of Limitation Act 1963. Therefore, you cannot sleep over your rights and go to courts after 10 years, 20 years, 30 years. Everything there is a time frame is there that has been prescribed by the statute. எல்லாத்துக்குமே ஒரு டைம் ஃப்ரேம் இருக்கும் 10 வருஷம் 20 வருஷம் கோர்ட்டுக்கு போனா courts will say you cannot come. That's what the law of limitation act speaks about. Now there is a contractual dispute is there. Again, for the breach of contract also, within the prescribed time you have to go and approach the courts. That means limitation starts. Now whenever you are going before the arbitration, then that time will be excluded from the limitation. You understand? That time will be excluded from the limitation. Limitation count பண்ண முடியாது. ஏன்னா arbitration போறோம்னு சொல்லி நம்ம சொல்றோம். That you can take a plea in the again if the arbitral what is called dispute phase, and if you come to the normal court will lost. Already limitation has been over. You come to the court. We went to arbitration. That time has been excluded by the proceedings. Right? So once a final arbitral award is pronounced by the tribunal, its original mandate concludes. ஒரு வாட்டி award declare பண்ணா மட்டும் tribunalக்கு powers இருக்காது. It becomes de facto or de jure. By operation of law, the powers of the arbitral tribunal comes to an end. Whether it is prescribed in the agreement or not is immaterial. You know the meaning of operation of law. ఇది అగ్రిమెంట్ లో ఉన్నా లేకపోయినా కూడా అంటే అగ్రిమెంట్ లో ఈ ఆర్బిట్రల్ ఆఫీస్ టెర్మినేట్ అయిపోతుంది లేదనుకోండి, బట్ ఇట్ ఇస్ ఇమ్మెటీరియల్ whether it is an agreement or not. Once an arbitral award has been passed, now it becomes de facto official. The mandate of the arbitral tribunal terminates by operation of law will come into picture. Right? Assumptions, presumptions, again it will come. You know meaning of presumption, assumption, so many things in evidence are. It is presumed that the mandate of the arbitral tribunal has been terminated once an award has been passed. Again, once an award has been passed, you know, if you go to the courts, you can ask for decree and judgment plus review. Review you can ask. Here, if you don't have power to correct an award, arbitral tribunal ஒரு வாட்டி அவார்ட் பாஸ் பண்ணா திருப்பியும் கரெக்ட் பண்ற கெபாசிட்டி இருக்காது, கோர்ட்டுக்கு இருக்கும். கோர்ட்ல you can file a review. You understand CPC section 113, 114, 115. Review you can file. Review of the judgment. Again, you cannot ask for a review of an award. You have to remember this. You cannot ask for a review of an award except to correct clerical and typographical errors only. He cannot entirely modify the award. What he can do, if any typographical error is there, any clerical is there, that one can be corrected. Again, that too by notice to other parties, and both the parties have come to the arbitral tribunal. He cannot change the content of the arbitral award. மாற்ற முடியாது. காரணம் டைப்பிங் மிஸ்டேக் இருந்தா, typographical errors இருந்தா தான் மாற்ற முடியும். Right? So according to the legal rules, the tribunal by passing the final award, it becomes functus officio. That means in operation of law, it has been terminated. Functus officio, no more functioning. No more functioning officially. Whether it is in the agreement or not, arbitral will become functus officio. Right? And its remaining responsibilities are highly limited. Something one game powers irukadu. He has been terminated. That's it. Only to what is called rectify clerical or topographical mistakes. Therefore, compliance with and enforcement of the award, compliance with and the enforcement of the award becomes a matter for the parties and national courts. You understand? Once an award has been passed, whether you are recognizing the award is not, it is up to the parties, right? Whether to enforce the award, it becomes the function of the courts. ஒரு வாட்டி award பாஸ் பண்ணாவிட்டு ஆர்பிட்ரலுக்கு ஒன்றும் பவர்ஸ் இருக்காது. அதை ரெகக்னைஸ் பண்ணணும்னா யார் ரெகக்னைஸ் பண்ணணும்? பார்ட்டிஸ் ரெகக்னைஸ் பண்ணணும். அதை என்ஃபோர்ஸ் பண்ணணும்னா யார் என்ஃபோர்ஸ் பண்ணணும்? கோர்ட்ஸ் என்ஃபோர்ஸ் பண்ணணும். ஈவன் ஒன்றும் இருக்காது. சிவில் சூட்ல என்ன ஆகும்? Court itself passes a decree and judgment, it will enforce. Here he cannot enforce his own award. Why? His mandate terminates montes officio. Once he passes an award, that is over. Right? So therefore, compliance with the enforcement of the award becomes a matter for the parties and the national courts. Right? The arbitral award is regarded as an instrument. Again, you know the meaning of the instrument? Yes. What is meant by instrument? Where you got this word instrument? About that is also transfer of property of instrument. Instrument means you are transferring certain rights and interests. Right? You are defining certain rights and interests by way of an instrument. Instrument and anything you are transferring something, some rights, some legal rights you are transferring. Again, it is an instrument recording the tribunal's decision, provisionally, interim, or finally determining the claim of the parties. It may be a provisional also. Provisional means interim, or it may finally determine the disputes of the parties. The award concerning the legal or actual dispute between the parties will be based on the obligations of the contractual terms. Award should be in consonance with the contract of the terms of the parties and determination of the respective rights and obligations of the parties under the contract. Whatever you are going for, arbitrator only ஒரு power இருக்கு. என்னன்னா நீங்க என்ன கேட்டா அதான் கொடுக்க முடியும். But that is different with the court. Court may give some other relief also that has not been asked by you. But he has to pass an award only based on your dispute only. Right? The award may also deal with preliminary but substantive issues such as preliminary and substantive issues such as jurisdiction of the tribunal. First, they will rule out the jurisdiction, applicable laws, and limitation of actions. Right? You know why? Once an award has been passed, several legal consequences will follow. You understand why award is binding? Award can be challenged. Award can be challenged. Whether you like it or not, it is binding. ஒரு party முடியல வெச்சுக்கோ, still it is binding. He will go for execution. That means it is going to affect your rights substantially. If you know the law, even if an order passed by the court is even without jurisdiction, it is binding on you. You understand? Even it is without jurisdiction, it is affecting your rights unless and until that order has been set aside by the higher courts. புரியுதா? ஒரு லோயர் கோர்ட்ல ஜூரிஸ்டிக்ஷன் கிடையாது லோயர் கோர்ட்ல, but they have passed an order, right? Simply you cannot tell that it has been passed without jurisdiction, it is null and void, it is not binding on me, I did not follow. The law says no. That null and void is declared by whom? Higher courts. ஒரு legal order இருந்தது, உங்களுக்கு applicable ஆகலன்னா நீங்க என்ன பண்ணணும்? ஹையர் கோர்ட் போய் அத செட் அசைட் பண்ணிக்கணும். That is the rule. Right. There are several legal consequences associated with the rendering of the various types of awards. Different types of awards are there. Final award, preliminary award, then additional awards will be there. So many awards. We are going to see different types of awards. You know, different types of degrees are there. Preliminary degree, final degree, preliminary and final, partly final and partly preliminary, minimum degrees. Likewise, so many awards will be passed. So many awards will be passed. Then we can challenge the different things. We are going to see when these types of awards will be passed. Right? So after the final award is issued, the tribunal's authority expires and the award is generally final, right? Binding. Next one is it is having res judicata effect. Res judicata effect. You know the meaning of res judicata? I think that you know only that word only. அந்த வேர்டு மாத்திரம் தான் தெரியும் அந்த மீனிங் தெரியும்னு சொல்லி I don't think it's res judicata res sub judice that I have already decided here arbitration in the board of the arbitration is given one decision you don't like the decision again you are going to civil courts for determination of the same dispute புரிஞ்சுதா என்ன மனிஷ் what is difference என்ன yesterday who have been gone to ground cricket ground you have to go downstairs Kamira data on the data on the vibe of 5 positions Darina whoever comes late 5 positions more if you answer 5 positions more 5 marks more for you yeah please right it is having res judicata effect you know why in some sense the arbitral award is can be equated with consent award in some sense you go consent there the award yeah please your focus is only for 10 minutes again you will distract 10 சின்ன பசங்க இருப்பா ஸ்கூல்ல they are having more focus than you they will strike for at least half an hour you don't have to focus for 10 minutes class illa happy class illa happy just yesterday I feel ashamed one guy was when principal is telling no class he's doing like this going huh no, I felt somewhat seems to be somewhat awkward for me. You see, I am connected to you. I am telling the class. You are telling Govinda. After 3 months, you can tell Govinda. Right? Huh? The class ke varthe na enga varani final year la viva anu vanga முதல்ல விஷ் பண்ணல இப்ப மாத்திரம் குட் மார்னிங் சார் ரைட் ஏன்னா ஃபைனல் வைவா வரேன்னு சொல்லி அங்க கண்ண பாக்கலையா ரைட் கண்ண பார்த்தா என்ன வரும் ரைட் ப்ளீஸ் so what I thought the Victoria moves I am telling yes focus every 20 minutes it's a human psychology will distract so I will make you something again I will bring your focus life the focus focus illana life the only you cannot achieve right yeah let's go Raymond always late right yeah please चलो योग போலாமா கிளாஸ்க்கு கிளாஸ்க்கு போலாமா இல்ல கிளாஸ் எடுக்கிறீங்களா கிளாஸ் எடுக்கறியா கிளாஸ் வெரி குட் எஸ் இன்னும் கிளாஸ் எடுக்கிற டைம் இருக்கு இன்னும் 12 மணிக்கு கிளாஸ் எடுக்கோ மூணே கால கிளாப்ஸ் அடிக்கும்போது அப்போ வீட்டுக்கு போகலாம். Still, yeah, and now we have to pray for this reason. Right? Now, after the final award is issued, the tribunal's authority expires and the award is generally final and binding and has a res judicata effect between the parties. Res judicata effect on the அதே dispute மேல கோர்ட்டுக்கு போனா the court says no. Right? Now, no claim can be brought in respect of the same matter. Right? Now, the arbitral tribunal makes many decisions during the arbitration process. Many decisions during the arbitration process. All decisions are not awards, but all awards are decisions. You see, all agreements are not contracts, but all contracts are all admissions are confessions, but all confessions are not. All confessions are admissions, but not all admissions are confessions. தெரியுமா admission confession என்னன்னு தெரியுமா? தெரியாது. தெரியுமா தெரியாதா? தெரியாது. படி தெரியாதுன்னு சொல்லுவாங்க. We don't know. Confession அண்ணா கோர்ட்டுக்கு நின்ன போய் சொல்றது confession. கோர்ட் இல்லாத யார் என்ன சொன்னாலும் அது என்ன சொல்லுவாங்கன்னா admission. Admissions are inadmissible. Court evidence எடுக்க முடியாது. Confession மாத்திரம் தான் கோர்ட்ல எவிடன்ஸா எடுப்போம். போலீஸ் என்ன சொன்னதெல்லாம் கூட என்னன்னா admission. Right? So like all decisions of the tribunal, all awards are decisions of the tribunal and not all decisions are awards. Right? So many decisions are made by the tribunal. Deciding the preliminary issue with respect to jurisdiction, with respect to the law that will be made applicable, so many things. Award means final determination of the dispute. Right? Now the term decision is generic and refers to the result of any conclusion or resolution reached after consideration, while an award is the decision affecting the rights between the parties. Award is going to affect your rights. You understand? One's right is detrimental to other person. Award passna award la vatanukku mathram da relief irukum. Vatanukku detriment irukum. Detriment will be there. That means it is going to affect your rights. Right? Like a decree and judgment, it is going to affect your rights. Now, while an award is a decision affecting the rights between the parties, all decisions cannot be enforceable. But award is enforceable, and which is generally capable of being enforced. Right? Several decisions of the tribunal aim at organizing the procedure, how you are going to conduct arbitration procedure ni ela conduct cheyali అనేది కూడా ఏంటది decision. It's also preliminary issues, decision of the tribunal. Adunda award paniyavu may relate to technical and procedural matters and are rendered without any formality or reasoning. Right? Such decisions are characterized as procedural orders. Procedural orders were substantive orders were, procedure is the law which is going to enforce substantive rights. Procedural என்ன எப்படி கண்டக்ட் பண்ணணும், எந்த லாங்குவேஜ், அவார்ட் எப்படி இருக்கு, இதெல்லாம் கூட என்ன procedure. Substantive என்ன representation of the dispute which is going to affect your rights. Right? Procedural orders are different from substantive orders. We have no difference between procedural orders and substantive. So many orders will be passed by the courts. You have to know what type of order, how it is going to be challenged. என்ன பண்ணணும்னு சொல்லி first we have to know. Procedural order, substantive order. Procedural order normally don't affect the rights of the parties. It affects only the procedure. Understand? It affects only the procedure. It's not going to affect your rights. procedural orders do not decide the dispute. Disputer decide one of the procedural orders, right? They simply make arrangements for the proceedings, right? They don't determine the dispute. It's only a procedure. For example, a procedural order may fix the hearing at a place different from the scene of arbitration. Here, parties may consent for one place of arbitration. Arbitrator may fix another place of arbitration. Again, that is challenge again. Parties challenge law, right? Order or refuse to order disclosure of the documents, set deadlines for the submission of documents in the time to the document submit சொல்லி ஒரு deadline கொடுப்போம் அது கூட என்னன்னா procedure right or indicate the parties the issues on which the tribunal would like to hear the arguments இதுல எந்த issues மேல நான் வந்து I am going to hear your case. These are all procedural orders, right? The other essential characteristics that distinguish an award from other decisions of an arbitral tribunal are as follows. These are the characteristics of the award. ஒரு வாட்டி award பாஸ் பண்ணா it assumes certain characteristics, right? First one is it concludes the dispute. Decree and judgment ever pass பண்ணுவா conclusively determining the rights of the parties. If you remember civil procedure code, decree and judgment will be passed conclusively determining the rights of the parties. If it does not conclusively determine the rights of the parties, it cannot be called as a decree and judgment. Decree and judgment is enna fully it has to determine your rights. Even award is also it should conclude with the dispute as to specific issue determined in the award so that it has res judicata effect. If it does not determine the disputes conclusively, no res judicata effect will come. புரியுதா? இவர் 10 இஷ்யூ கொண்டு போனேன் 10 இஷ்யூ டிட்டர்மைன் பண்ணா அந்த 10 இஷ்யூ மேல திருப்பி வரக்கூடாது. The court had determined only 9 issues. Remaining one நாள் நீ போலாம் திருப்பி. res judicata effect வராது திருப்பி. You understand the technicality, right? So it concludes the dispute has to specific issue determined in the award so that it has res judicata effect between the parties, right? This is first. Second characteristics of an award and since it is a final award, it terminates the tribunal's jurisdiction. So the mandate of the arbitral tribunal comes to an end. ஒருவாட்டி award pass பண்ணா it will determine the dispute. res judicata வரும் திருப்பியும் அதே dispute பண்ண கோர்ட்டுக்கு போலாமா போகக்கூடாது ஒருவேளை determine பண்ணலன்னா then you can go to the courts. Next one, that terminates the tribunal's jurisdiction. Next one is disposes of parties respective claims. The engager is going to dispose your claims also, right? Next one may be confirmed by recognition and enforcement. How you are going to confirm the award? By giving recognition. Award எப்போ value கொடுப்ப அந்த recognize பண்ணா, right? Then you are going to என்ன சொல்றாங்க என்ன பேர் என்ன உதயகுணா what's your name? No, full பேர் என்ன Chandra Prakash, right? Now why I am asking you is whoever disturbing the class, I am going to disturb you in the Viva. Yes. Class I am no. Normal person இந்த சொல்றவங்களுக்கு நான் வந்து சொல்ற difference I can recognize your recognize face. I can easily recognize your face, names, right? இங்க இருக்கிறவா they will tell and go, but I am not going. I am seeing you. I am what is called whatever. எல்லாரும் பார்த்துட்டு இருக்க வைவா 6 days வைவா இருக்கு சந்திர பிரகாஷ்ல நெக்ஸ்ட் ஒன் எப்போ கிளாஸ் முடியுதா எப்போ ஊருக்கு போகலாமா that is the attitude your attitude determines your altitude ஒரு சிச்சுவேஷன் வந்தப்போ அதை நீ பாசிட்டிவா பார்க்கறியா நெகட்டிவா பார்க்கறியான்றது very important you understand for example the situation comes which you don't like you will resort to some other things don't go for positive things bad நடந்தா கூட என்ன பண்ணணும் you have to go to what positive things negative things போகக்கூடாது புரிஞ்சுதா சப்போஸ் ஏதாவது ரிலேஷன்ஷிப் பிரேக்கப் ஆச்சுன்னு வச்சுக்கோ தாடியெல்லாம் வளர்த்து தண்ணி அடிச்சு வீட்டுல தூங்க விடாது புரிஞ்சுதா புக் எடுத்து படிக்கணும் என்ன பண்ணணும் புக் எடுத்துங்க படிக்கணும் புக் எடுத்து படிச்சா என்ன வரும் நாலேஜ் வரும் புரிஞ்சுதா எனக்கு அதே மாதிரி நாலேஜ் ரைட் எனக்கு அதே மாதிரி நாலேஜ் வந்தது ஒரு பிரேக்கப் 40 books 42 breakups 4200 books I became interest like it right புரிஞ்சுதா வரும் see the positive things in your life for me எந்த situation வந்தாலும் see the positive don't lose your emotional intelligence you know the meaning of IQ intelligent quotient but intelligent quotient kana EQ is more important emotional quotient will be there emotional quotient kana என்னன்னா என்ன நடந்தாலும் stay calm வீட்ல வைஃப் திட்டாலும் stay calm வீட்ல வைஃப் அடிச்சாலும் stay calm that should be your emotional resilience right may be challenged in the courts of the place of arbitration right award pass panna recognize panna that is the legal affair you can go for enforcement execution so on so the arbitration and conciliation act does not provide a definition of an award there is no inherent definition of the award except it states what arbitral award includes an interim awards that's what it says right right these are the different types of awards right the arbitration conciliation act envisages the following fundamental types of awards different types of awards are going to be caused by the arbitral tribunal இப்போதைக்கு உங்களுக்கு தெரியாது but you have to learn this final award interim or partial award additional award consent award agreed award and default awards so how many types of awards 5 types of awards let me recapitulate final award interim or partial award additional award consent award agreed award then default award right we'll see tomorrow got something to allow question mind that right very good photo எடுத்துக்கோ yeah எல்லாரும் அப்படியே செல்ஃபி எடுத்துக்கோங்க எடுத்துக்கோ ఏం డౌట్ सेट असे अभी का सेट असे ओके why you are married on what grounds you are preferring to not satisfied with every which part of the award is against అప్పుడు ఏం చేయాలంటే సెట్ అసైన్ చేసుకోవాలి డిస్ట్రిక్ట్ కోర్ట్ కెనాట్ గివ్ సెట్ అసైన్ చేసుకోవాలి మళ్ళీ అంటే ఫార్మల్ the court don't have power to correct the award except for the అర్థమైందా set aside. Note number 6 to the
Silence. Silence. When a land acquisition award is passed, can it be challenged? If it is to be challenged, on what? Land acquisition won't be applied. If any disputes are there, that also can be challenged. Enhancement of compensation, boundaries of the compensation, title disputes, all these things are required in L.A.B. before the appropriate court. If that court doesn't accept your award or dispute, then it is must have been accepted. So several land boundaries in Tirumala, I was able to excite all four months. 11 rupees per feet was passed by the DMO. It was enhanced by the court 30 rupees and confirmed by the High Court. One number it.
What do you want? So we are moving on to the next part of the drafting meeting and conveyancing. This is the conveyancing part. So I hope you have understood with regard to the principles that are to be laid out by drafting a pleading, that is whether it is a civil matter or a criminal matter. Now we are moving on to next important thing as a lawyer. You need to know what are the requisites that have to be maintained while you are drafting an agreement. Okay. It's very important. Now, over the way, the people would ask you the thing to draft it, right? So for that, now what is a contract? It's already displayed on the board. See, agreement which is enforceable by law is a contract. So, ஒரு agreements எல்லா agreements contracts ஆக முடியாது. There are only certain agreements which are enforceable by law can be executed before the court of law. Now, what do you mean by what is it enforceable by law? If you approach a court of law, you will get the remedy. It is called enforceability. And section 2 clause H of the Indian Contract Act says is that a contract is an agreement which is enforceable by law. So a contract an agreement has to be there and it shall be legally enforceable. And agreement means what? That is every promise our set of promises becomes consideration for each other becomes the agreement. Now, என்னோட property உங்களுக்கு arrange பண்றேன். நீங்க அந்த property consideration 10 lakh rupees arrange பண்றீங்க. So these two, the promise that you make and the promise that you make are both promises for one thing, right? Performance of the contract. Then only the contract will be enforceable. Now, under what all circumstances this said agreement could be enforceable is that under Section 10 of Indian Contract Act. Indian Contract Act was a basic or parent act for all the drafts or contracts or drafts. Section 10 is the basic foundation for drafting a deal. So some requisites has to be complied if you wanted to enter into a contract. First one, obviously there should be two parties, promisor as well as the promisee. Right? Now, secondly, the parties entering into the contract must be having the capacity to enter into the contract. They should have the competence. What do you mean by that? Now, Section 11 and Section 12 of the Contract Act says that if a person wanted to enter into a contract, both the parties must be of sound mind. They should have the capacity of sound mind. Secondly, they should have attained the age of majority to which he is subject. Might be India 18, now maybe in another country it could be 60. So if he is a 60-years old who's in another country, going foreigner, then what the law which he is subjected to must be complied as enough. Thirdly, he should not be disqualified by law to enter into contract. What do you mean by that? Law shouldn't restrict you from entering. For example, if you are an alien enemy, then you can be person under different circumstances. In all these circumstances, you cannot. The law is barring you from entering into the contract. So that is the second requisite, the capacity to enter into the contract. Third requisite, the consent that you give must be free. Free consent as per Indian Contract Act, Section 14 says that there is no coercion, undue influence, fraud, misrepresentation, mistake. With the vitiating factors later only then the contract is rendered to be void, not void, voidable. Is rendered to be voidable. Right? It cannot be enforced in the court of law. Then what should be there? Consideration. The consideration that you give must be lawful consideration. For example, now 10,000 rupees only in return. You are giving me 10 grams of gunsa. Is it valid? No. Because if you approach a court of law, you will not be able to enforce the same. So the consideration you do also should be lawful. And the object, the purpose for which you are entering the contract should be lawful. You are asking me to rent the house. Another purpose for which you are renting the house is for gambling. Gambling is something which is forbidden by law. So the purpose for which you are entering into the contract should be lawful, and the anything which the law renders to be void should be entered. Okay, that is for example, as per section 26, agreement in restraint of marriage is void. 27, agreement in restraint of trade is void. Agreement in restraining legal proceedings is void. Then, if the terms of the contract is uncertain, then it is void. If it is a wagering contract, it is void. So, when the law itself says that there are certain factors rendered to be void, those contracts cannot be entered. So, if a party wanted to enter into a contract, these requisites has to be covered. But there are certain exceptions. For example, consideration payment was mandatory, right? Exclude a factor non or the issue. That is a consideration without, a contract without consideration is void mentioned under section 25 of the contract. But in that act itself, it states that there are certain circumstances where you without consideration you can enter into a contract. For example, some gift. Gifts are not consideration payment. The contracting agency, as per section 185 of the Indian Contract Act, you need not have consideration. In and out of natural law and affection, near and dear transfers of property by your registration. Then also you need not transfer the property. They need not have the consideration. So there are exceptions, but this is the main requisite if a person wants to enter into a contract. He has to comply with all these requisites. Okay, we should be competent. There should be two parties. The parties must be competent in contract. The parties must give the consensus freely. And consensus and identity of minds. Same thing with the same sex. Right? And lawful consideration, lawful object. ಇದೆಲ್ಲ ಏನ್ ಸೊನ್ನೆನಾ? Now, if you wanted to draft an agreement between the parties, all these requisites had to be compliant. இப்போ ஒரு சேல் அக்ரிமெண்ட் நீங்க எழுத போறீங்கன்னா you want to write a sale agreement. Next you want to discuss about sale. Sale எழுதும்போது என்னது? The parties must be competent. ஒரு lunatic, for example, a lunatic, but he is of lucid intelligence, he is of sound mind. Can he enter into contract? Yes, because at the time when he is of sound mind, he is able to get a rational decision. அது contract enter ஆக போறது சரியா தவறா இல்ல he is able to understand the consequences of the contract. Then also, if he is a lunatic and enter, provided you have to prove while entering into the contract he was able to make a rational decision. Right? So, when I was saying agreement of property was sale பண்றாங்கன்னா, the seller should be competent to enter into the contract. Likewise, the buyer should also be competent to buy the sale. Right? All the rights and liabilities that you have already learned at the transfer of property. Now, moving on. Sale. Now, sale is being defined under section 54 of Transfer of Property Act. Sale and the transfer transaction. Under Transfer of Property Act, we are selling an immovable property. Movable property will be dealt under Sale of Goods Act. So, sale of immovable property is being sold under the provisions with regard to that is mentioned under the Transfer of Property Act. Now, what is being transferred actually here? The whole property. That is, there is no restriction here subject to section 1011 of the Transfer of Property. You are ultimately like full ownership, enjoyment, everything is being transferred to the other person. So section 54 says about sale of immovable property. So sales and transfer ownership in exchange of price or promise paid. That is that the person give you the consideration. You partly promise that if a promise contract is after 6 months when it will be registered, we give the same half of the amount. So sales and transfer ownership of the immovable property. Next, have you heard about the Registration Act of 1908? Now, Registration Act, section 17, they have stated certain agreements or certain instruments have to be mandated to be registered. One among is the sale of immovable property. That is, if the value of the immovable property is more than ₹100, then it has to be registered. And the formalities also be mentioned under the same under section 54. That is, when a transfer of tangible immovable property, the value is ₹100 or upwards, then it can be effected only by a registered instrument as per section 17 of Registration Act. Okay, otherwise explicitly they are mentioned, it should be compulsory instruments that has to be compulsory registered is mentioned under section 17 of Registration Act. Now, in the case of the property value is below ₹100, it can be effected either by way of delivery or by way of registration. That depending upon whether register பண்ணி transfer பண்ணலாம் or by way of near delivery is enough. So how do you know the person has ultimately given you the property? That is by putting that person in the possession of the property. Now property sell பண்ணிட்டு now if you don't give the property, now you don't பண்ணிட்டு then it is not an effective transfer has to be made. So, when if you wanted to have an effective transfer, absolute transfer, you have to transfer the ownership of the property to the buyer. So these are the requisites of a sale. Now, sale can be executed by the seller. And what are the and sale execute by what all are conditions that has to be mentioned? That are you registering right now and giving the consideration then and there, or you are taking time after 6 months and time period to and also, while you sell the property, there are some rights on the side of the buyer and liabilities on the side of the seller. That is, if I want to sell the property, if there is any encumbrances in the property, tax payable, another charge, the mortgage in property, I should sell the property free from encumbrances, and that should be mentioned in the deed as well. That I have sold that is, I am selling the property free from encumbrances. What do you mean encumbrances? That there are no liability over the property. And there are charge or mortgage or attachment or I'm selling the property free from encumbrances. Then, and most importantly, how I got the property must also be mentioned. Whether I got the property by a victory or in a nama, sale in a by partition when I got the property. How I acquired how I acquired the property, that has also to be mentioned. Why? To ensure that the buyer, that I have the absolute ownership over the property. Because as we learned in the section 7 of Transfer of Property Act, if a person wanted to transfer a property, he should be competent to transfer. That is, he should have the ownership to transfer. Or else, he should be authorized to transfer. If a power of attorney holder, say execute the real owner is giving him the authority to execute the same. So, the power of attorney for the authority. He will agent principal or he is an ostensible owner. So, how you got the power over the property has to be mentioned. Now, this is the format of the sale. Now, sale date first you have to write the dates in which you are executing the sale. Now, this agreement to sell made at dash day of dash month of dash year between whoever the seller and buyer has to be mentioned. The seller would be normally mentioned as the first party. The buyer would be mentioned as the second party. If there are more than that, third party, fourth party, you get mentioned likewise. And detailed description of the immovable property had to be there. What kinds of property? What is the extent of the property? Well, the sense of property is there. Then what is the boundaries? So as to identify the property, you have to mention the property boundaries. All the description of the property had to be there. And the taluk, and the creation, all those things have to be mentioned. And the terms and conditions. Each terms and conditions has to be there. That the first party, what is the consideration that they had received from the second party? Then, that the property is free from what kind of property? Whether it's commercial property or residential property, agricultural land, any type of property had to be mentioned. Then it is free from encumbrances, all those things. Copy of this would be circulated to my. And if there is any liability, minor property liability will come. All those things had to be mentioned. And this is important. In witnesses whereof the first and second party have executed this agreement to sell at this place, the month and date and year, everything had to be mentioned. And first above written in the presence of the following witnesses. And it shall be attested by minimum of 2 witnesses and shall be countersigned by the 4 parties. This is the format for sale. So sale of execute panel the days in which you are executing the sale, date, month, year have to be mentioned. Then, who are the parties? First party always will be the seller. second party would be the buyer. If there are more than that, big number, you want to join property na. First and second party are the owners of the property. Third and whoever is buying will be the buyer. Now you have to mention the scheduled property. Property schedule had to be mentioned in a tabular format or in a description where you have to mention what is the property, what is the nature of the property, extent of the boundaries, everything had to be mentioned. How he acquired all those terms that had to be mentioned. If there is any part performance that he had, the person has paid you in full, that also had to be mentioned. Whatever it is, depending upon the facts and circumstances of the case, that had to be mentioned. This is clear and shall be signed by the two witnesses and countersigned by the parties. Clear. Now, another type of conveyancing is mortgage. What is mortgage? Mortgage number 58 of section 58 of transfer of property and instant mortgage. Now, property மேல ஒரு interest நம்ம transfer பண்ணணும். We are not transferring the property as a whole. Absolutely, if you transfer, it becomes same. Now, the property where a particular interest that you have transferred to the other person for what? For securing the money that we have borrowed. Now, we now, in order to secure that amount, we are giving the property to the other person. But we are not, there are 6 types of mortgages depending upon the interest that you transfer. Simple mortgage, traditional sale mortgage, user structuring mortgage, English mortgage, then deposit of title deed mortgage, nominous mortgage. So there are different types of mortgages wherein oral mortgage oral characters. For example, simple mortgage there is no delivery of property. You are giving the right to the other person, stating that if I make a default the payment of money, you can sell the property, or you can sue me. Sue file money, you can execute the same property and get it. Conditional sale mortgage, you are ostensibly selling the property to the other person and giving few conditions. That if I don't make the payment, that condition shall further sale shall become absolute. If I make default to the payment of money, so if I repay the money, that sale shall become void. Then you have to retransfer the property back to me. So these are few conditions that you can keep in conditional sale mortgage. Now conditional sale mortgage is the rights and conditional sale mortgaging is the rights and mortgaging. That is the person who has given you mortgagee, the one who has given you the money, the creditor here. The only right that is available to a conditional sale mortgagee is a suit for foreclosure. Can you learn? Or an anomalous mortgagee having such a right. Suit for foreclosure reduction right to prevent under suit for foreclosure. You are preventing the right to redeem, the mortgagee's right to redeem prevents under suit for foreclosure. Then there is usufructuary mortgage. But in usufructuary mortgage, what happens? You are transferring the property totally to the other person. And he takes the benefits out of the property and compensates with the money that he has borrowed, that he has given. Then English mortgage absolutely transfers to the other person. But there is a condition stating that state can become absolute. Then title deed mortgage that generally happens in the back or then anomalous mortgage. 2 or 4 characters in the anomalous mortgage. Okay, so in mortgage also, there are certain circumstances you need to transfer the property, certain circumstances you need not. You have to transfer the interest over the property. For interest, a simple mortgage interest, and default and other things, then you can sell the property or file a suit against me and get the remedy. Right? Now, moving on, but mortgage number, mortgage number enter பண்ணும்போது you have to register in certain circumstances. That is what is property value or what is money value. Mortgage money value, mortgage money இருக்குல்ல. Even though the property is 100 crores, I might mortgage only to somebody. So whatever the value of the money, if it is more than 100 rupees, then it has to be compulsory registered. If it is below that, it will not be registered. That is what is mentioned under section 58 cross sale defines a mortgage and section 59 of transfer of property as says about the formality of a mortgage. General specific ஒரு எல்லா ப்ராப்பர்ட்டி ஒரு எல்லா சாதத்தையும் வேக்கன்ட் செய்வாங்க. ஸ்பெசிஃபிக்னா I transferring I என்னோட நான் ஊர்ல இல்ல I need to sell a property only with regard to that sale and execution of the property and the rights. General means என்னோட எல்லா rights whatever property I have got even ஒரு case institute பண்ணனும்னா என்ன impose பண்ணனும்னா general government I got to அது ஆமா only to what extent power என்ன கொடுத்திருக்காங்க property sell பண்றது இல்ல property change பண்றது இல்ல வாடகை விட்டுட்டீங்கன்னா அந்த வாடகை வாங்குறது only to that extent you have the right. You don't have the right to sell for your own interest. உங்க இஷ்டத்துக்கு எல்லாம் sell பண்ண முடியாது. only the last of the other person. We will learn next class how to do it. Please remain silent, please. So section 58A of Transfer of Property Act deals with mortgage. The mortgage is a transfer of interest in a specific immovable property for the purpose of securing the payment or the money advance. நம்ம என்ன காசு வாங்கிருக்கோமோ அந்த பேமெண்ட் செக்யூர் பண்றதுக்காக மட்டும் தான் we transfer the interest over the immovable property, not the whole property, no ownership, nothing. But depending upon it, we have all six types of properties. Now, where the principal money na the money that you have borrowed from the other person. When the principal money is more than 100 rupees or upwards, it shall be effected only by a registered instrument and shall be attested by two witnesses. Likewise, if it is less than 100 rupees, it can be only either by registered, either by or by taking of the property. This mortgage is clear. Now we will see a format how a mortgage deed has to be drafted. Now this is with regard to a simple mortgage. Simple mortgage on a rights and that he has only a right or suing for money or there is no delivery of property. So if you want to give a mortgage, உங்களுக்கு இந்த concept தெரிஞ்சாதான் you can draft a one. If the person who has the client comes and asks you to draft a one, you need to know the law. Only then you can do it. That's why I have given a brief idea with regard to the mortgage. So likewise, the person who transfers the property is called the mortgagor, and the property to whom it is transferred or the creditor here, the person who gives the mortgage money is the transferee. So this is an example of a simple mortgage deed. That is the person's details hereinafter called as the mortgagor, and what he has borrowed a sum of rupees dash, and he says that he shall repay the same within the specified time period. And simple mortgagee, what happens? The mortgagor is personally buying himself, is giving him the promise that I shall pay the same amount. So that promise has to be mentioned here. I promise to pay the aforesaid amount with interest thereon at the rate of cash, with the period of cash, from the date of execution of the deal. And you have to mention the secure property. What is the property you are keeping as security? Description as to the security of the property. So secure property. So So now upon being defaulter in the repayment of loan, including in the interest thereon, the mortgagee shall be entitled to enforce against the said house any remedies of a simple mortgagee. So simple mortgagee in the item that has to be mentioned here. That is, he can enforce against the property. That is the right against the simple mortgage. And it shall be attested by witnesses and signed by the mortgage. This mortgage deed is clear. If it is conditional state mortgage, it's simple piece, just one paragraph. Are there any important paragraph? The date in which you are executing, that is I think written as order. Yeah. Then the details of the parties. Mortgage or details that the property you are keeping as security has to be mentioned, and the date in which you are repaying the amount has to be mentioned, and the remedy available to the simple mortgage. That he can execute he can realize the mortgage money out of the property of the mortgage. Is it clear? Now, what is lease? Huh? நம்ம sale என்ன பார்த்தோம் sale is actually a transfer. Mortgage என்ன பார்த்தோம் it is a limited interest is being transferred to the other person. Now under lease you have to deliver the property and the property right to enjoy the property is being transferred to the other person. Okay. In lease you have the right to enter. For example, நம்ம வீடு rent எடுக்கிறோம் இல்லனா ஒரு property land agricultural land நம்ம எடுக்கிறோம் for what to enjoy the property to take benefits of the property but for a particular period of time. Depending upon this particular period of time, there are different types of mortgages. So, different types of lease, leasing opportunity, lease from time to time, then monthly payment lease, yearly, annually income broker lease. So, there are different types of lease. So, lease is also a transfer where you are transferring the right to enjoy the property to the other person for a specified period. Here. And in the lease or registration formality is that if the lease property value is more than 100 rupees, then it has to be compulsory registered. This is also mentioned under section 17 of registration act. Compulsory register section 17 it has to be mentioned. So lease is defined under section 115 of Transfer Property Act. So lease is a movable property is transfer right to enjoy such property made for a certain period of time. Now lease that consideration could be any, even money's worth, even services rendered, even crops, even any shares, anything could be in return in a contract of lease. Now, if it is a year-to-year lease, illa oru varsham renew pandra monthly lease illa if there is early reserving annual rent lease, then if it is more than 1 year lease, all these things has to be compulsory registered. Then if it is less than 100 rupees, near delivery of possessions in the no need to register the same. So this is the basic idea of a lease. So lease, there are two parties, lessor and lessee. Lessor is the one who gives the property. Lessee is the one who enjoys get the benefits out of the property. Anyway, lessor he can give certain conditions. Likewise, lessee can also propose certain conditions that enterprises are or whether he has a right to sublet or not. That is very important. Sublet panna koodaadu. The terms will give this if the person sublets, then he can be evicted. Even lease can be terminated. Then he shall hold the property in good condition, shall not make any alterations or constructions without the consent of the lessor. Or he can use it, and also likewise, lessee can also have the right. If the product is being commissioned another he has entitled to get it repaired. Whatever condition that you have learned at the lease can be mentioned here. Now, this is with regard to lease of a dwelling house. The obedience of the lessor and what is the consideration that they have received, and the lessee hereby covenants with the lessor as follows. The terms and conditions. What interest, what monthly payment renta, or if it is annual payment renta, whatever it is, then he shall be liable to pay all the charges, then maintain the property, then he shall not sublet, all those things. And the lessor hereby covenants with the lessee as follows. Their terms and conditions can also be mentioned. And it shall be signed by two witnesses, countersigned by the lessor as well as the lessee. Yes, lease is here. And what is gift? Exactly. Gift, what is the nature of the property that has been transferred? What kind of properties can be transferred at a gift? Anything like that. Existing movable as well as immovable property can be transferred at a gift. Under section 122 of Transfer Property Act deals with gift, and the person who transfers the property is called the donor, and the person to whom it is transferred is called the donor. Now, as Dharma said, in a transfer of gift, there is no need of consideration. Without consideration, but the person must transfer voluntarily. Now, voluntarily, the property will be transferred. And what kinds of property should be? Existing movable immovable property. And if you understand property, then definitely it is part by section 6. But other existing movable immovable property can only be transferred under gift. Now, if the donor is proposing to transfer property to the donee, this gift had to be accepted by the donee during the lifetime of the donor and while he has the capacity to make the gift. Then the property now will transfer பண்ணுறேன். The person who is receiving it, he had to accept it. நான் ஒத்துக்கிறேன் accept பண்ணணும். How you have to accept? During the lifetime, நான் இறந்து போனதுக்கு அப்புறம் நீங்க accept பண்ணா that is not a valid deal. Or else, I should have the capacity to transfer. And the property back வந்து எப்படி பண்ணிட்டு போயிடுச்சு. இல்லைன்னா I remain insane. எனக்கு the property execute பண்ற capacity இல்லை. So all the property அழிஞ்சு போச்சு. By act of God அது இல்லாம போச்சு. So if a property got to be executed by way of gift, then the property had to be accepted by the donee during the lifetime of the donor and also while he has the capacity to make such a thing. Now, registration, coming to the registration of gift. Gift immovable property, irrespective of its value, had to be registered. Immovable property, value or that property had to be registered irrespective of its value. Register but if it is a movable property, near delivery is income. A value of law if it is a movable property, just delivery of the property will be enough. That is with regard to gift. So gift is a transfer from the donor to the donee without consideration and doing it voluntarily. So gift is defined under section 122 of Transfer Property Act. And also, can a person who is not in existence, அவருக்கு நமக்கு transfer பண்ண முடியுமா? Can a donee be not in existence, incapable of a person? We can give to a person, even a child in the womb, or is yet to be born, அவங்களுக்கு கூட property. But then, on behalf of that child, another guardian or another person had to accept the same. Even if you transfer a property to a minor, the minor acceptance pattern authority because he is barred by section 11 because he cannot accept the contract. So the guardian of the other person can accept on behalf of the minor child or child in the womb or the person is yet to be born. So gift is a transfer of certain existing movable as well as movable property made voluntarily without consideration by one person for the donor for another person for the donee or accepted by on behalf of the donee. That is maybe the donee might not have the capacity to accept. So on behalf of the other person he can accept the same. Gift is different from sentimentalization. Now acceptance. Acceptance, how can we accept? It shall be accepted during the lifetime of the donor and by has the capacity to use. So such acceptance must be made during the lifetime of the donor and while he is still capable of giving it, and he shall if the donor dies before acceptance, it is void. He should accept it before dying, he should accept the same. Then how a transfer property is to be effected after section 123? For the purpose of making a gift of equal property, the transfer must be effected by a registered instrument signed on behalf of the donor and attested by at least 2 witnesses, and the purpose of gift of movable property by either by registered or by delivery property. Here, movable property now in respect of its value has to be registered. After 100 rupees of it has to be registered, and gift of movable property by registration or by delivery property can be effected. Now gift deed. Gift deed likewise. This gift deed is made on dash day or dash month or dash year between whom the donor and as well as the description about the donor. And we have to mention what is the property that you are transferring. If it is movable or the description, if it is immovable or the description, and beneath it. The donor out of natural love and affection and without force or compulsion or undue influence and the free will in full possession of his body senses, thus gives, transfers and conveys his entire property, which is getting thereto, upon the said donee and profits advantages everywhere. Absolutely together with all rights and peace. When the property shall be transferred, absolutely you shall not restrict it. Or it will be barred by section 10 and 10. Then witnesses whereof the donor says and describes there was in presence of the witnesses the present day, the schedule of the property. Then this is very important while you transfer. Acceptance must be signed. That is accepted by the donee or on behalf of the donee and signed by him and accepted on his behalf of the person. Here. And shall be signed by the witnesses? No. So this is some few calculations with regard to transfer property and calculations of all these things. Sale, mortgage, lease, and gift. Clear, right? And that's one way. Tomorrow we'll take few more. Please sit down, please sit down, please sit down. One second. Rashmi ma'am, ask. Rashmi ma'am. Akash, Akash. Thank you guys.
Good morning. So there is an announcement regarding Moot. Okay, Julie Madam will address within short period of time. Okay, so listen carefully. If you have any doubts regarding Moot competition, Julie Madam will clarify. Okay, within short period she will announce. So kindly listen.